I want to disinherit my no good, for nothing, rotten child. Can I do it? Yes, you can. Yes, you can. If that child was no good, rotten, good for nothing, you can disinherit the child. And if the child was wonderful and joyous and loved you more than life itself, you can still disinherit that child. You can disinherit a child for a reason or no reason at all. It's your money, your assets, your belongings, and you are completely in control of what you give or bequest to anyone. You are not required to leave anything to any of your children. So if you have 5 children, and you want to leave to 4 and leave 1 out, you're allowed to do so. If you have 1 child and you want to leave everything to the Salvation Army, you can do that also. A spouse is a different circumstance, but a child, there is no legal obligation to provide any death benefit to a child. Now, if you don't have a will, you can't do this. And the state plan, the plan that takes place, if you don't have a plan, that's called the laws of intestacy. If you rely on intestacy, then your child will inherit. Your blood children will inherit. Your legally adopted children will inherit. You can avoid that if you don't want your child or children to inherit. You need to do a will. In the will, you can say, I, Frank Bruno, I intentionally leave no money for my child, John Smith. I intentionally leave John Smith out of my will for reasons known only to me, for my own reason, or for no reason at all. You don't have to specify the reason. Probably even best if you don't. John Smith was no good for nothing drug addict, and I won't leave money to John Smith. You're making things murky. What if, you don't need to say that? And you shouldn't say it. I wouldn't allow you to say it. I don't think any other attorney would allow you to say that. Why kick dirt up? Doesn't really matter, because the law doesn't require you to give a reason. It just needs to be in writing. And you have to make certain that you didn't just forget about the child or unintentionally disinherit a person. You have 5 kids and you say, I leave to all 4 of my children in equal shares. Well, maybe that 5th child has an argument. You only specified 4. You forgot about me. I don't know. We'd have to see the factual circumstances of that case. But you want to be explicit, and it's possible, and you can do it, and I can help you do it. I might talk to you about why, and does it make sense to do it? How do you feel about it? And, are you now giving that child the ability to contest your will for one reason or another? There's some legal reasons they might be able to assert. We work through that in advance. We talk about it, we discuss it, and we figure it out. Frank Bruno, Law.com.